Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Good morning. Bonjour. Situation en République du Kenya.
Situation in the Republic of Kenya in the case the prosecutor versus William Samoei Ruto and Joshua Arap Sang. Case number ICC 0109-0111, and we are in open session, Mr. President.
Thank you very much. Appearances, please.
Good morning, Mr. President, Your Honours. For the prosecution, I appear this morning, Anton Steinberg, and with me, Ade Omofade, Lara Renton, a new face, Mr. Peter Schotsman from the Language Services Unit, who will be providing the prosecution with language support for Swahili witnesses, Thomas Franzinger, and case manager Grace Go.
Thank you. Mr. Kigen-Katwa, your team.
Morning, Mr. President and Your Honours. For Mr. Sang is present and is represented by myself, Katwa Kigen, Caroline Busman, Logan Hambrick, Joel Posek, and Hona Lanham.
Mr. Khan.
Good morning, Mr. President, Your Honours. Mr. Ruto, who has been excused, is represented by David Hooper of Queen's Counsel, Shamla Alagendra of Counsel, Miss Lee Laurie, legal consultant, Shalini J. Raj at the back, and Miss Grace Sullivan. Your Honours, my name is Karim Khan.
Thank you very much. Before we get to the matter of the witness testimony, witness 535, a few housekeeping matters. Then, prosecutor, can you tell us now how many witnesses we will be hearing in this session?
Your Honour, I sent an update via email earlier this week to summarise. The first witness, witness 535, is present and ready to testify. After that, the picture is less rosy. Witness 469 was assessed medically on, I believe it was Monday, and was found not yet fit to travel. She was asked to come back again on Friday for a further assessment. However, in the interim, one of the investigators who met with her, who's of course not a medical expert, but conveyed to me that her condition does not appear to be improving, and she remains pessimistic that she will be able to in fact travel on Friday. Indeed, if she is able to travel, her assessment is that she would require in any event frequent breaks, which would probably extend her evidence well into the following week. With respect to the expert, unfortunately, he has declared himself unavailable due to other commitments which he's unable to divest himself of. He requests that he be called during January, February or March next year, when his commitments at the university will be less. So unfortunately, the prognosis is that apart from the witness currently before court, unless things improve dramatically with witness 469, it is likely that we will only have one witness.
It does not appear that firm plans can be made on the basis of the second witness. So it is prudent to seriously consider other alternative. The expert is not available, so we cannot plan on that. I mean, we rule that out. During our last discussions on this thing, there was the matter of, is that witness 36?
It was witness 32, I believe, Your Honours. And
32? Sorry, 32.
And there were two other witnesses which the prosecution had mentioned. I think it was 128 and 409.
I would urge that while we deal with the testimony of witness of 535, for us to again revisit the possibility of calling any of those other witnesses, the shorter ones. I know that for strategic reasons there are times that counsel will prefer to move a certain way, counsel on both sides, but the needs to move with speed may also require that adjustments be made, and we can't always have the world as we want it.
I will indeed make the necessary inquiries at the first opportunity.
Thank you very much.
Mr. President, can I just say to assist, because I know my learned friend had some concerns about time estimates for witness 32, if that witness was to come up. I can say that I do not envisage that I will need days with the witness, and I think he's a witness definitely that we could finish, start and finish next week if he could be brought over to The Hague. So I hope that reassures my learned friend and gives some insight to the Chamber.
Mr. Kikin-Katwa?
Mr. President, I adopt the same position as Mr. Ruto's team.
Thank you.
Your Honour, can I just say, because as far as the other two are concerned, the preference would be witness 32, because from what I recall, the state of preparedness for the other two was not all that we would wish, because they were much further down the order. So, Your Honour, our preference would be witness 32. Of course, that witness 32 was part of the 8 witnesses that we originally asked to be called first. So we are relatively prepared for that witness, and so there would be no delay that the defence would have to, no application for an adjournment the defence would have to make for witness 32.
The good thing it was switched off. Now to give the oral reason for our excusal of Mr. Ruto from today's sitting. First, I begin with the procedural history. The request for excusal was made in the context of a broader discussion about the court's calendar for the remainder of the year. This discussion was initiated in light of developments in the Kenyatta case. It is to be recalled that in the original judicial calendar that was in place in the Kenyatta case, the case was to be in session from the 12th of November until the Christmas break. That necessitated an adjournment of the Ruto case because of the common personnel and logistical support for the two cases. But on the 31st of October, the Kenyatta case was adjourned and put over, rather, the commencement of that case was put over to the 12th. From the 12th of November, when it was supposed to start, to the 5th of February 2014. That then freed up time for activity in the Ruto case. Consequently, on the 1st of November 2013, the parties and participants were invited to make submissions on the possibility of using up the freed up time to do some work in the Ruto case. The prosecution indicated that it needed 2 to 3 weeks to line up its witnesses and requested that at the conclusion of the hearings in 2013, the court adjourn until the 13th of January 2014. Both defense teams submitted that the hearing should be adjourned after the 8th of November until January 2014. On the 4th of November 2013, further discussion occurred on the matter. The parties agreed to discuss whether 2 witnesses could be called between the 8th of November and the 9th of December 2013. The prosecution submitted that for logistical reasons, the witnesses it intended to call could not start before the 20th of November. The Ruto defense wished to start on the 18th of November. Yet again, the discussion continued and culminated on the 8th of November 2013. The Chamber invited discussions or submissions from parties, and those submissions were received. The option was put forth again on whether to start on the 18th or the 20th of November 2013. The Chamber notes that the Ruto defense wished to commence with the next witness on the 18th of November 2013, while the prosecutor indicated that in order to call its witnesses, it wished for the hearing to commence no later than the 20th of November 2013. On the 8th of November, after hearing the parties, the defense for Mr. Ruto raised the matter of excusal of Mr. Ruto from presence at trial from the 18th to the 21st of November 2013 and made their request accordingly. The request was stated to be for purposes of allowing Mr. Ruto to be in the Republic of Kenya while the President of Kenya attended a meeting of African and Arab states which has implications for national security and regional security. The prosecution objected to the request, arguing that alternative measures short of excusal were available. Specifically, the prosecution raised the possibility of starting the next hearing on the 22nd of November 2013. The legal representative for victims also opposed the request. Against the foregoing background, the Chamber ruled on the 8th of November as follows. 1. That the hearing would resume again on the 21st of November 2013 in hopes of completing the testimony of 2 witnesses by the 29th of November 2013, and 2, that the request for excusal regarding this date was granted, with reasons to follow. Mr. Ruto's counsel filed a waiver of presence for the hearing of the 21st of November 2013. The Chamber recalls that among the limitations to the trial chamber's discretion under Article 63(1) of the statute, as set out by the Appeals Chamber in its judgment of the 25th of October 2013, the absence of the accused can only take place in exceptional circumstances. The Chamber considered that the relevant meeting which the President of Kenya was scheduled to attend outside of Kenya is one of exceptional importance. The Chamber noted the arguments of the Ruto defense that Mr. Kenyatta's attendance at this meeting necessitated Mr. Ruto, in accordance with the Constitution of Kenya, to be in Kenya for the period of the 18th to the 21st of November 2013. The Chamber also considered the request in view of the parties' other submissions regarding the court's schedule and its obligation to conduct the trial in an expeditious manner. In particular, the Chamber recalled that further hearings in this case before the end of the year had only been scheduled following the recent adjournment of the Kenyatta case announced only on the 31st of October 2013. Therefore, it could have been reasonably expected that Mr. Ruto would be in Kenya at that time and would have been able to attend ordinarily to his duties as the Deputy President of Kenya. The Chamber also notes that this excusal is limited to a single day and considers that granting the request will result in Mr. Ruto's absence only for a period which is strictly necessary. Such a limited excusal is consistent with absence from trial remaining the exception and not the general rule in this case. The Chamber also notes that Mr. Ruto's explicit waiver has been duly submitted to the Chamber and considers that his rights will be fully ensured in his absence through representation by counsel. It is for these reasons that the Chamber granted a request for Mr. Ruto's excusal in today's proceedings. That is the end of the ruling. Moving forward, there was a matter that was brought to the Chamber's attention in the last days. Our counsel now prepared to speak to it. Is Steinberg?
Which matter is Your Honour referring to?
The matter of excusal of Mr. Ruto.
Yes, Your Honour, we are prepared to speak. Well, we have, of course, submitted written submissions in this regard. And the genesis of this request was information that was conveyed to the ICC and, of course, to the prosecution by the ASP to the effect that the Kenyan delegation had changed and that it would henceforth be led by Mr. Ruto and not the previous leader, who I believe was the Honourable Samuel Chepkonga, MP. The ASP was requested to adjust the speaking list accordingly. The speaking list is arranged, as I understand it, in accordance with seniority of the speaker.
Do we have evidence of that?
Your Honour, this was conveyed orally during a meeting on Tuesday, or was it? It might have, I think it was on Tuesday, Your Honour, but we don't have. I have not appended anything. I made that submission in my filing, but I have nothing in writing which I can append to that. The crux of the matter, of course, is that this led to the prosecution sending a request for confirmation of certain facts to the defence. In this request, the prosecution brought to the attention of the defence the information which it had in its possession, which indicated that Mr. Ruto would attend and possibly address the ASP meeting on the 20th of November as the leader of the Kenyan delegation. We brought to their attention that this appeared to be at odds with Mr. Hooper's submission on the 8th, which indicated that Mr. Ruto's presence would be required in Kenya on that day and the following day. And as a result of this information, we posed 3 succinct and clear questions to the defense. The first was whether the circumstances as put forward by Mr. Hooper on the 8th had changed, and in particular whether Mr. Kenyatta would still be attending the meeting or whether he would be, in fact, back in Kenya. The second question was, given what appeared at that stage to be changed circumstances, whether Mr. Ruto would indeed now be able to attend the hearing today. And the third was whether or not the defense accepted that the Chamber's previous orders relating to the discussion of the merits of the case in the media would also apply to discussions by Mr. Ruto in any address he might make to the ASP.
Mr. Steinberg, perhaps I should have put it this way when I invited you. The defense filed a written response on the matter.
Yes.
My question should actually have been whether you still wish to pursue your original application in light of the submissions that the Ruto defense have made in writing.
Your Honour, of course, that is a slightly different question, and the answer is that if indeed Mr. Ruto, as it now transpires, was not to be in The Hague on the 20th and was not to address the ASP and it is indeed required in Kenya, then the basis for the request falls away. Of course, if the defense had simply said as much in response to what I believe was a very clear request, then there would have been no need to submit the request to the Chamber and involve the Chamber in the first place. But that having been clarified, or the facts having now changed, I'm not sure which it is, the request is no longer necessary and I would submit it as now moot.
Scan.
Mr. President, we...
Noting that the prosecutor says the request is now moot, do you have any response?
with your leave, Your Honour, yes, because the defence response was absolutely proper. We couldn't have been clearer. We said that the Deputy Head of State, Mr. William Ruto, would be as leading the delegation at the ASP, which is correct. We said that we are aware of all relevant court orders and they would be continued to be complied with. And we also told the prosecution that in the event there was any change of circumstance, we would bring that immediately to the attention of the Chamber and the prosecution. In those circumstances, for the prosecution to have relied once again on a backroom gossip and hearsay is really lamentable. This is a heavily worked defence team, an overworked defence team. We have very important matters to grasp. Some of us have been on this case for only 4 or 5 months, and for the prosecution to waste, we say, court time and needlessly in this manner is really regrettable, and I said so in the filing, Your Honour. The defence was clear. We're not here to satiate the curiosity of the prosecution regarding the intentions of an Assembly of State Party member, except to the extent that it impinges upon any order of the court. No order of the court was impinged upon, as the filing reveals, and as my learned friend Mr. Hooper stated in court. His Excellency, the President of the Republic of Kenya, was in Kuwait at the time of filing. He's due back today. And today, as we indicated, Mr. William Ruto will be leaving Kenya to fulfill his obligations here in court. Your Honour, the whole tenor of the application was regrettable. We also disparaged and deprecated the rudeness of the prosecution to refer to the President of Kenya as Kenyatta. Your Honour, he is not an accused in this case. At the very least, the President of Kenya can be afforded a degree of respect in this case where he is not an accused. Mr. Ruto should be called Mr. Ruto. We're not insisting upon His Excellency. But, Your Honour, it does smack of spite, and we do deprecate it. Not only the tone, the lack of necessity for it, but, Your Honour, they've wasted the resources of this court and put the defence to the trouble of responding to a matter that there was no need to respond to, given the very clear response that we gave, that we're cognizant of all orders of the court, we are complying with them, and we will appraise the court in the usual manner if there was any change of circumstance. Your Honour, those are my responses, and I'm most grateful.
So your point is that you as counsel were not aware of any change in circumstances that might have led the prosecutor to their application. For instance, he was saying that there was some request made for a change of speaking order at the ASP in order to accommodate Mr. Ruto's speech.
Well, Your Honour, it seems the prosecution isn't even clear on that point, because we don't know who said what to whom, where, in these backroom discussions. There's no formal filing, no documentation, no letter that's been presented, whereas the prosecution has been able to lay their hands on and disclose the letter, the official letter from the President of the Republic, giving the credentials for the Deputy President to lead the delegation, as well as the alternate members, the Attorney General and the Cabinet Secretary for Foreign Affairs. Your Honour, at the time the prosecution contacted us, it's our understanding that the President of Kenya was in Kuwait at that summit. He was in Kuwait for that summit at the time we responded. There was absolutely no need for this filing, and Your Honour, so there was no change of circumstance.
Your point was that there was no evidence of any request to alter the speaking order at the ASP, to you, as far as you know.
Not to my knowledge. Not to my knowledge.
Was filed.
I don't know. I can't obviously say
yes.
whether or not it was raised by other members without instruction or the rest of it. Not to my knowledge.
All right. Thank you. Prosecutor, indeed, just to note, we've indicated before that in these proceedings we require civility from both sides to one another, also to witnesses and accused persons, and we had indicated that common titles are to be used. We want to remind the parties of that. It applies not only in oral submissions in the courtroom, but also in written matters that are filed in court.
As the court pleases, Your Honour, I should point out, of course, that both Mr. Ruto and Mr. Kenyatta were addressed as such initially, and then by way of shorthand, subsequently, were referred to by surname. So in the prosecution's view, the necessary civility had been observed, and it was a question of economy.
No, the convention, as I understand it, is you can say Chile Ebo Suji the first time, and subsequently Mr. Ebo Suji repeatedly. That is the convention. Let's follow that.
As the court pleases. And of course, as regards my learned friend's other submissions, that his response was clear, the prosecution obviously takes issue with that. In our submission, the response was opaque to the point of being evasive. And had my learned friend simply said that your information that Mr. Ruto will be in The Hague on the 20th is incorrect, your information that he will be speaking is incorrect, that nothing has changed, then this filing and all of this brouhaha that has emerged around it would have, of course, been unnecessary. Of course, if my learned friend had also confirmed, as was requested, that their understanding was that the Chamber's orders that Mr. Ruto should not make statements in the media pertinently applied to any statements to be made at the ASP, or that he was not going to speak, again, the matter would have rested there. But my submission, Your Honour, is no matter how much spin can be put on this, the plain wording of the answers and the response are there for all to see. And I have nothing further to add than that.
I think, Mr. Khan, we can leave it at that.
Well, Your Honour, just with one thing, and I'll say no more. Your Honour, I don't accept, and I think the use of spin is rather unfair, but I'll say no more.
We will now move to the next, to the real matter of the day, which is witness 535. There is a matter we need to attend to, and that would be submissions concerning his protection in the courtroom, an application of which has been made by the prosecutor. We will. Is it something we can deal with in the public session, Mr. Steinberg?
Your Honours, I will address you on this matter, and to the extent that Your Honours have seen the prosecution's filing, there's nothing further to add. It only remains, if Your Honours have further questions, then it may be that we have to go into private session.
Thank you. There will be oral submissions, would there be, from the defense on the matter? Can you safely speak to it in the public session, or is it safer to be in private session?
I think, Your Honour, I'm advised private. I was going to say public, but I think better to be cautious, so private.
All right. We will go into private session for submissions on the protection of the witness.
Nous sommes en audience publique, Monsieur le Président.
The court officer, we are in open session, Mr. President.
Thank you very much. The Chamber will deliver its ruling on the application for the protection in the courtroom, protective measures to be accorded to prosecution witness 535. On the 18th of November 2013, the prosecution requested protective measures in the form of 1. Image and voice distortion, 2. Use of pseudonym during testimony, 3. Limited sessions in camera to prevent identification, and 4. A reduction to public records where necessary. On the 20th of November 2013, the VWU submitted their recommendations to the Chamber. In sum, they recommended that the measures urged by the prosecution be granted for this witness. The Chamber has received oral submissions from counsel for both Mr. Ruto and Mr. Sang, as well as counsel for victims. Having considered the request by the prosecution and the assessment provided by the VWU, as well as the oral submissions made by counsel in private session, the Chamber hereby grants the application in the following measures: the use of pseudonym for the duration of the trial, voice and image distortion for the witness, testimony to be given in private session when necessary for purposes of preventing dissemination of identifying information about the witness, and that portions of transcripts generated from private session be classified accordingly and reductions made. That is the order of the Chamber. Prosecutor, I see that we have about 20 minutes to morning break, but we can get in a few questions within that time, at least introductory matters.
We certainly can, Your Honor.
Is the witness on hand?
To the best of my knowledge, yes.
The blinds will come down for the witness to be brought in then. While that is being done, I see Mr. Khan on his feet.
I'm grateful. Your Honour, it's early days, but I wonder perhaps if my learned friend is in a position to give an indication as to the estimate for the length of examination in chief of this witness. It would be an indication would be very much appreciated.
So, Mofade, you know, of course, why that request is being made.
I know why it was made, Your Honours. The testimony of this witness is expected to be relatively short. At the very most, I expect the testimony to finish by the first session of tomorrow. We might even be sooner than that.
Thank you.
Nous sommes en audience
The
publique.
court officer, we are in public session, Mr. President.
Thank you very much. Witness, welcome to the courtroom. Whenever a witness comes, when I say welcome to the courtroom, I sincerely mean that they should feel comfortable in the courtroom, because the courtroom belongs to you, as it belongs to all of us sitting in here. So you feel comfortable as you are with us to give your testimony. The court officer will administer an oath to you.
Nianze kusoma.
The witness, would you like me to read the document out to you?
Yes.
Ninatamka kwa dhati ya kwamba nitasema.
Witness, I solemnly undertake to speak the truth, the whole truth, and nothing but the truth.
Thank you very much. That is what we expect from you while you are with us today, just to speak nothing but the truth and the whole truth. You do that through questions and answers. The lawyer for the prosecution will ask you a question. Mr. Omofade will begin today. And when he is finished, the lawyer for Mr. Ruto and the lawyer for Mr. Sang will also take their turns in asking you questions. It is important that you listen very, very carefully to the questions they will ask you, and then answer their questions very truthfully to the best of your ability. In doing this, it's important for you to give us only evidence that you yourself perceived. It's important for you to remember what it is you saw, what it is you heard, what you felt, and things like that from your own perspective. That is what's more important for us. Please try not to guess at answers to questions. If you do not understand the question, try not to think what you think the question is about when you don't understand it. If you do not understand the question, tell the lawyer asking you the question that you do not understand the question. They will repeat it. Once you've understood it, then you begin with your answer. Keep it short and simple. There is a procedure that helps also to ensure that your answers are recorded properly. That is, speak slowly, but not very slowly. Also speak in little chunks of information, because there are some interpreters who are also assisting us to understand what you're saying. They will require some pauses while you speak, so you don't speak continuously without a break. Speak in little chunks, take a break so that they can interpret, as well as the court reporters as well. They are recording what you're saying. They also need some pauses from you when you give your answers for them to be able to do their work. If you keep those in mind, it will be your testimony before the court would have been helpful, and we will thank you very much for coming. Prosecutor.
Your Honours, I'm grateful. There's a PIS form that's been handed out. I've asked that it not be placed in front of the witness until he's taken the oath. I wonder if that could be done now.
Have you distributed it already?
To the parties, yes, Your Honour.
Do we have a copy?
Your Honours, it might be in the bundles that have been placed in front of you.
I see it, yes.
Good morning, Mr. Witness.
Nzuri.
Witness, good morning.
Name is Ade Omofade. I'll be asking you some questions this morning on behalf of the prosecution. Do you understand that?
Ndio.
Witness, yes.
We've met previously. We met 2 days ago during a witness preparation session. Do you recall that?
Ndio.
Witness, yes indeed. Message from the English booth. Could counsel please be informed that there has been frequent overlapping of microphones so far? Thank you.
Your Honours, there's a CV of the witness that has been prepared and kindly agreed to by both defense teams.
That is in the PIS?
Your Honours, it's at page 3 of the PIS, the English version, and there's a translated Swahili version at page 4 of the PIS. And, Your Honours, because this has been agreed to, what I propose to do is to simply ask the witness to read through the Swahili version on page 4 and to acknowledge or to state whether or not he agrees with the information therein.
Witness, can you read that to yourself, but not aloud, please? Review the information provided. That's what the prosecution wants you to do. Do not read it out aloud.
And just to guide the witness, Mr. Witness, please turn to the last page, page 4, and you will see that that part is in Swahili. If you read that quietly to yourself, please.
Sijapata kuelewa ni karatasi ipi.
The witness, I do not understand which page you are referring to.
Can somebody go point out the Swahili page appearing at page 4?
Do you have the relevant part now, Mr. Witness?
Ndio nimeupata.
Yes.
Niusome sasa?
Would you like me to read the page?
Can you read it to yourself? Do not read it out aloud. The lawyer wants you to review the information that appears on that page, because he will ask you later to confirm whether you agree with it. But for now, just read it silently to yourself. Don't read it out aloud.
Ndio ni ya kweli.
The witness, the information contained in the document is correct.
Thank you, witness. I'm going to ask you a few further questions. Your Honours, I think we probably ought to go into private session just for about 2 minutes.
We go into private session now.